On February 20th, 2001, Danny Kylo argued against the United States government's use of thermal imaging technology to indict him for drug charges. Earlier today, June 11th, the court presided by Chief Justice William Rehnquist made its decision. Kenneth Lerner offered the prosecution, while Michael R. Dreeben offered the defense.
The reason why this case was brought to light is because a Department of Interior agent was suspicious that Kylo was growing marijuana in his house. The agent used thermal imaging technology to look into Kylo's house and was searching for high-intensity light consistent with the lights used to grow marijuana. The technology was part of the reason why a federal magistrate judge issued a search warrant on his house. After the warrant was obtained, it was found that Kylo was growing marijuana. He was then arrested on drug charges. Kylo contested the evidence gathered because of the means that it was gathered by. The Court of Appeals, though, affirmed the initial charge, holding that Kylo had no subjective expectation of privacy, as well as the fact that the thermal imaging technology did not compromise his privacy.
This was then brought to the Supreme Court, which is why we must ask today's constitutional question. Does the use of thermal imaging devices to detect relative amounts of heat emanating from a private home constitute an unconstitutional search in violation of the Fourth Amendment? And to answer this question, both sides offered contrasting analyses. However, only one could win in the end.
Kenneth Lerner, the prosecution, posited that technology has the ability to penetrate into our private lives, and that's the problem. And that he, quote, thinks any time that the government is seeking to capture information from a private place like the home, and they cannot do it with their own unaided human senses, then they may not use technology to do the same thing. Basically, Lerner argued that because technology aids the government in looking into our personal lives by superseding natural human senses without permission to do so is a violation of privacy, and thus a search in the eyes of the Fourth Amendment, it requires a warrant. Because this action required a warrant but did not have one, it should thus be deemed unconstitutional.
Contrastingly, Michael Dreeben offered the defense, claiming that because it does not, quote, penetrate the walls of a house, it does not reveal particular objects or activities inside of the house. Essentially, Dreeben claimed that since the device was monitoring what's happening to the outside of the house, the structure, rather than the inside, it was in no way invading the privacy of Kylo. Furthermore, Dreeben explained that when looking at the precedent case of Katz versus the United States, the degree of the information being searched was important as well. Whereas the words coming out of someone's mouth were the thing being searched within Katz, in this case, it was only the building's change and its heat energy. In the end, neither attorney offered an incorrect analysis. However, Lerner's reasoning fell closer to that of the Supreme Court justices that Dreeben's did. Associate Justice Antonin Scalia provided the majority opinion, claiming that whereas here the government uses a device that is not in general public use to explore the details of the home that would previously have been unknowable without physical intrusion, the surveillance is a search and is presumptively unreasonable without a warrant. He continued to explain that regarding the house, all details are intimate details because the area is held safe from prying government eyes.
On the other hand, the dissenting opinion was given by Associate Justice John Paul Stevens, which claimed that, quote, observations were made with a fairly primitive thermal imager that gathered data exposed on the outside of Kylo's home, but did not invade any constitutionally protected interest in privacy. Therefore, they would be considered, quote, information in the public domain.
In the end, the court ruled on a 5-4 decision in favor of Kylo. This means that Kylo versus the United States likely is going to serve as a precedent as well as other cases have. It's not unlikely that in this new information age, our ever-growing technological development, that the precedent created by this case is going to be needed. Justice Scouter presented an excellent description of this when he stated that it doesn't tell you that because it, at this point, is not sophisticated enough to do it, but it takes you one step in the way. With this in mind, it's clear that the court had the intention of setting a precedent regarding technology. Essentially, although the technology might not be able to do something at this point, in the future, there's likely going to be some technological innovation that allows it to do so. Hence, it's going to be interesting to see how this court case develops and its usefulness in the years to come.